Hi everyone, it's Grant Abbott speaking and welcome to this session. I've called it New Ways of Doing Old Things, but essentially we're looking at estate planning, but not estate planning as you would see it from your traditional lawyer. And in that regard, generally lawyers most, if you've ever done estate planning with lawyers, have a tendency to look at assets which you hold outside your trusts. And inevitably, they will take monies inside superannuation and transfer it over to an estate where traditionally you'll have, if you've got kids, you'll end up with 4 or 5 or 3 or 4 testamentary trusts, etc. So that's the traditional way of doing things. But if I go to the next slide, which I think you'll find fantastic, I did a Google search looking for a parchment and found this will from 1778, where obviously the client has gone to a solicitor, drafted up a will. There's the seal down there, the little wax seal, they've signed it. And then effectively the wax seal was with their chop or their stamp, so it actually gives it the authenticity. And really, they've written out, or it's been handwritten in calligraphy as to what their desires are in terms of their estate. And it's funny because, have things really changed that much? At the moment, we still go to our estate planning lawyers, and it could be, for example, I live up here on the Sunshine Coast, and I could go up to the local lawyer near Twin Waters, who basically professes to be an estate planning lawyer. Whether their knowledge around estate planning, discretionary trust and SMSFs is great, on a scale of 1 to 10, they're probably around about a 2 or a 3 when it comes to discretionary trust and SMSFs, but they are still estate planning lawyers. You'll go and see them. They'll give you a fact find out what you've got, where you are at the moment, who you'd like to give the stuff to, and then you'll draft up your will, and then you're off and running. But that really hasn't changed since 1778, which is the year that we were discovered, well, I shouldn't say, we were settled by white settlers, in fact, convicts, in 1776. So it just shows you how far things really haven't changed. So this is what I know, and I know this from years and years of experience. You guys do too, because you've been dealing with lawyers, you've been in the estate planning trenches for many, many years. And a lot of us, particularly around the SMSF side, have been completely disenchanted with the whole process. So what I know is that it's not 1778 anymore, and really there's a great opportunity for specialist estate planning advisors, ones who can facilitate the estate planning process across trusts, SMSFs, and other assets for their clients. As you're going to see, I'm going to show you a little bit later on our use of robotic processing automation in the LightYear Docs platform, which is really the most advanced of its kind around the world, and we've really taken that legal documentation workflow process to the next level, has enabled us to build for you a perfect, what I call a Moat document workflow, enabling you quickly and efficiently, and I'm talking in about half an hour, to help clients build a bulletproof moat around your clients' affairs. And that includes your own as well. For me, from all I have seen, is that the best advisors of this are both the accounting profession and also financial planners. And I'll give you 5 reasons for that a little bit later on. Now, for the most part, if you're dealing with trusts and wills, testamentary trusts, etc., SMSFs may be a little bit different, particularly if you're doing an SMSF death benefit trust. There's no need for licensing, just a commitment to real results for clients and their families. For me, it's an opportunity we've all been waiting for a long time for. And I just want to give you a point, is that, so I've got from Catherine, hopefully everyone else's sound is okay. So Catherine, if you go back to your line, you'll find, or your invite, there may be a phone number you can ring in on. Otherwise, it will be recorded and it will be sent to you a little bit later on. So quite often, because we're using the webinar, the internet, everyone else's sound is okay. So hopefully it gets a little bit better. So it's great strategy work and also great fees. Now, here's something I just want to tell you is that over the next 20 years, now listen to this, over the next 20 years, 2,000 billion, or what does Clive Palmer say, 2,000 or 2 million million, or $2 trillion is going to be passed from the war generation, the baby boomers, down to the next generation. Now, when you have a look at that, typically an estate planning challenge costs at least 10% or more in terms of the estate in relation to the payment of legal fees. So potentially, we've got a, thank you, Robert Port. Captain Cook landed in 1770, so thank you for that. I've got my times mixed up. But potentially that means that in excess of $2 trillion is going to be paid. So we're looking at $20 billion in legal fees. You can see why this is an absolute feast for the lawyers. And what we want to do is, out of this process, we want to make sure that, well, this is a Richard Brand, so you've got a great opportunity. I'll come back to that a little bit later on. We want to start building a moat for you and your clients around their structures and their affairs, so that it becomes impracticable and makes it difficult that any lawyer sitting outside here who's on a no-win, no-fee basis, that it's very hard for them to put money out of pocket, time out of pocket to get over that moat. Now, if it was just, obviously it's a property just sitting in an estate, then that's completely different. But the bigger the moat, the better off we are. So for me, estate planning is not a static process. At its essence, it is about looking after something that is high in importance to your client, their family. Ask your clients, what is the most important thing in their life right now? Generally, it'll come up for, particularly if you're looking at clients with a bit of wealth to them, it'll be their health, it'll be their family, and more importantly, it'll also be their a secure income stream or secure wealth. Now, from that perspective, if you ask them what's the most important, I find 9 out of 10 people will say their family. And ask yourself that, what is really important in your life at the moment? And if it's a family, then we need to look after the family. But, and here's the but, and this is what my mum told me, it's not the wide casting family. Your clients are frightened of blended families, de factos, and their children from other relationships, and much more. And you can see that we had a issue just recently. Tony Anamoulis, my legal partner for Abbott-Family, we did an estate, a will and testamentary trust for a client. They wanted a non-vesting testamentary trust, which we were able to achieve. They went to their solicitor in Bunbury. And again, when I talk about solicitors in various areas, I'm talking metaphorically. So yesterday I said that I think I wrote about a Gold Coast solicitor who is famous. In fact, there is no famous Gold Coast solicitor. So again, it was a metaphor from my perspective. But the main thing is this solicitor in Bunbury had been sitting on it for 18 months, and we effectively built a moat within the space of 2 hours for her. And that takes a lot of weight off your client's shoulders. Just think of it yourself. What weight is sitting on your client's shoulders, and also yourself, the fact that you haven't got a moat. Now, here's the interesting one. The Family Provisions Act, and that's in every state, allows any eligible person who feels they have missed out, so they're either not included in the will, or they were included in the will, but they weren't properly looked after, to take a legal action against the estate. Now, it's not against the SMSF trustee, and it's not against the trustee of the discretionary trust or family trust. It is against the estate. So you can see why, if we have a look at it, there's a tendency that if we're pushing monies from superannuation into the estate, so it hits a will or testamentary trust, it doesn't matter how beautiful we've set that up, effectively it's going to be open to challenge. Now, I'll pull this is from New South Wales Family Provisions Act. Who is an eligible person? It includes the wife or husband of the deceased, a person who was living in a de facto relationship with the deceased, including same-sex couples. So that seems fair. a child of the deceased, including an adopted child. Now, what about this one? A former wife or husband of the deceased. God, if I died, they'd be lining up forever, unfortunately. A person who was at any particular time wholly, entirely, or partly dependent on the deceased, and who is a grandchild of the deceased. Or is it the particular time a member of the same household as the deceased, a person with whom the deceased was living in a close personal relationship at the time of the deceased person's death? And can you imagine, you can understand why, I've got Tony on the line. Welcome, Tony. You can see why people are obviously concerned about relationships. Now, I've pulled up, I actually did a blog, an article on this a while ago, but I just want to show you something which I think is quite interesting. So this is from April the 1st, 2018. It's in Perth. I'll just blow it up so you can have a little bit a bigger look. A Supreme Court judge, oh, by the way, any contestation, I don't know if that's a word, any contesting of a client's will goes straight to the Supreme Court. And when it goes to the Supreme Court, guess what happens? Legal fees go up. You need to have a senior counsel, and it gets extremely expensive. It's a minimum of $100,000. Now, a Supreme Court judge has launched a scathing attack on lawyers who feasted on a small family estate with their indefensible legal fees, describing it as a scandal that brings the profession into disrepute. Justice Jeremy Cortai's withering takedown was aimed at the lawyers involved in the case of Angela Miller, who was contesting the will of her late de facto partner, Andre Taylor, who left his entire estate worth about $600,000 at the time of the three-day trial last October to his two adult children, Elizabeth and Philippe. In a recent judgment, it was revealed the combined legal costs were potentially more than $500,000 in a case involving 6 lawyers, one from interstate, which should only have had 2 according to the judge. The small estate had been ravaged by legal fees, he said. The costs on this matter are not, as counsel for the executor described them, unfortunate. They are a scandal to the administration of justice and bring the legal profession into disrepute in the eyes of the public. Estates are not there to be feasted upon by lawyers, but to go to the beneficiaries and those who might be entitled either under the Will, the Administration Act, or the Family Provision Act. No citizen of this community being informed of the costs incurred relevant to the amount of the estate could be anything other than horrified. Family provision matters are generally not complex, and costs of this magnitude relative to the value of the estate are inexcusable. So again, if we have a look at that, that's pretty typical. In fact, I've seen a few just recently that have ranged at least of that size, certainly not that commensurate that side. They've been around about $2 million, and to date, the legal fees have been above $200,000, which is my 10% rule. As you can see here from the Family Provision Act, that in essence, really, there's a huge ambit of claim. And generally, most lawyers will run on a no-win, no-fee basis. And you can see them advertising in the local papers all the time, whether it happens to be here in Sunshine Coast, over in Bunbury, in the Gold Coast, in Sydney, wherever, Newcastle, it doesn't make any difference. Now, to the extent we can put a moat around our clients' affairs, it just makes it more difficult there. And that's where the moat comes from. We want to channel that. We want to put this moat around our clients' affairs, making it too difficult for the lawyers to challenge on the outside. A lawyer is not going to go and put the resources, the time, the money into doing a Supreme Court case unless they've got a surefire chance of success, which we're going to look at. I'm not sure, are you there, Tony, at all? Or you've probably got a better idea on that for me. So let's have a look at the 5 reasons accountants and planners are the best estate planners. First off, the large majority of our business clients and those with sizable assets use discretionary trusts and SMSFs for asset protection purposes. We do that because the Bankruptcy Act protects those assets sitting in discretionary trusts and those assets sitting in a self-managed super fund. Importantly, even when we are bankrupt, accepting pensions, lump sums paid from self-managed super funds are excluded from our trustee in bankruptcy. These are the perfect asset protection vehicles. And when we have a look at it, if we can structure it right so that these are essentially where our assets are, and for the most part, accountants 101, we're continually pushing the advantages of streaming for discretionary trusts, but putting investment properties, putting shares, putting businesses in these discretionary trusts. Why do we do that? For asset protection purposes. The same way, putting money into SMSFs, it's for asset protection purposes. But, and here's the big but, when we've got them in there, it's not only asset protection during the life of the member or the beneficiary or the holder of those assets, in obviously indirectly through the SMSF or alternatively through the discretionary trust. It is also, if we structure it right and build a moat, it also covers later on down the track. I'm going to show you this in a case study going very shortly. Now, what we've got to look at is for those assets sitting outside the discretionary trust in the SMSF, effectively, we're in a position there that they are protected. They're effectively up for the will and the testamentary trust, and they are open to challenge. So what we've got to do is start to build that moat. So reason one, the 5 reasons, accountants can look across all of the client structures, including bucket companies, and ensure they're protected with a moat. And that's important because when we have a look at it, and I'm going to cover the estate planning side, then what I'm going to do is we're going to have a look at the particular issues around the provision of legal advice. And then I'll make sure that I get Tony from our office to make sure that he gives his tuppence worth as well, and he can actually talk about it. It looks as though, Tony, you're not signed in as a panelist, so you can't speak, unfortunately. So maybe go back to the original invite. Oh, in fact, I think Ash actually changed that, so sorry about that. What I'll do is we will come back with you some information later on. Now, accountants know their client structures, they've built them, it's asset planning 101. So they know what's in there and they can build a moat around the SMSF and also the family trust. Reason 2, lawyers lack tax and knowledge of discretionary trusts and SMSFs and push superannuation into a challengeable estate. Why is that? Perhaps if I was a conspiracy theorist, you could say, well, once it goes into the estate, because you look at Andre Taylor, he did have a will, and you think, well, what was going on there? He had a will, but it ended up being contested by lawyers anyway, and charging $500,000 in legal fees for that contesting. So I remember when I went through law school, both law school, unfortunately, Masters of Law, I did a taxation specialty, but I remember going through law school, we were taught about trusts and discretionary trusts, but we had 6 lectures on the taxation of all entities. So lawyers' tax ability or tax knowledge is very, very minimal unless they are specialist tax lawyers, such as Tony, for example. Reason 3, accountants and many planners have long-term relationships with their clients and their families, so they're empathetic to the importance of building a moat. If you've had clients for 5, 10, 15 years, you know about their family, you've put insurances in their family, you've found out who the beneficiaries are, you know whether there's unpaid present entitlements with the family, which are the good kids, which are the bad kids, who might take a challenge against unpaid present entitlements. That's the nature of your relationship. Lawyers are transactional. So if I went to the local solicitor here, or a Gold Coast or Bunbury, and I said, I'd like you to do my estate, they'll draft up a will. It might take 3, 4, 5 or 6 weeks. I'll pay them a fee anywhere between $2,000 to $20,000. And as a consequence of that, what will happen is that I won't see that lawyer again until perhaps I buy a property and I might go them to conveyance. So if I look at that, what we can have is, if I have a look at that, then effectively we can be in a position that really that long-term relationship is a big thing. Now, this is a fun one, the trusted advisor. And again, I'm just going to have to jump out of this. If you've got any questions, just put them online. Tony is there sitting online and more than happy to answer your questions as you see fit. I just wanted to show you this. I think this is funny from the Australian Lawyer. So this is from the Australian Lawyer, so it's not a US publication. Light aside, lawyers are as trustworthy as prostitutes. A new study undertaken by Princeton academics have concluded that lawyers are about as trusted as prostitutes. Two academics set about investigating how scientists are perceived compared to other professions, only having some interesting results arise. The research paper was subsequently peer-reviewed and published by the US National Academy of Sciences. It theorizes that trust and respect must be based on the perceptions of warmth and competence. And to test it, the authors asked 116 people to rate a whole raft of professions. So you can see here, in terms of warmth and competence, lawyers are very competent, but they have no warmth. So they're equivalent on the trust level as you can see there, lawyer, over here, a prostitute. Garbage collector is above a lawyer. CEOs aren't obviously well trusted, but look at accountants. Accountants are equivalent to scientists. They're equivalent to a whole range of other professions, not far from a professor or an engineer or a doctor. So I thought that was quite a funny state of affairs there. So let's move on and look at a case, a couple of other ones. So accountants are well known as being trusted advisors, and planners to a lesser extent. Planners, I know the planning profession has had a really hard time. There's been a lot of people who have moved out of the planning profession, but I would encourage you, in fact, go down this estate planning specialization. You do have the empathy, you do have the ability to walk warmly with the clients. It enables you to recast your relationship with a client. Now, the final one, reason 5, what I've found from working with them, and we've had a lot of great advisors and accountants and planners, such as John Grokey over in Johnson Grokey in Adelaide. There's been a whole raft of them who are doing extremely well with their clients in terms of the estate planning process. I even saw an article recently from Hill Lawyers suggesting again that financial planners should go down this estate planning process. Now, from what I've seen, it's not just one person you're looking at. You'll need to look at the whole family in terms of succession. So if dad dies, who's going to then take on the appointorship in the family trust? Who's going to be, as you'll see, we're going to be talking about shortly, who's going to be the leading member of the SMSF? Who's going to be the executive of the estate? Who's going to be the EPLA in case something happens, if dad loses capacity? We need to go, and if that person dies or becomes incapacitated or doesn't want to act, or they're overseas, who's the next person? And who's the next person after that? And that's what succession is. You'll see as we go through this case study, that is the big issue for your clients and yourself. Look at it. If you are the titular head of your family, if something happens to you, whether it's death or incapacity, or you simply don't want to take on that responsibility anymore, who's the next person who's going to come in? And if they're in the same position, if they're dead or they're incapacitated, who's the person after that? And it's not just in the executorship, it applies across the SMSF and also the family trust or the discretionary trust. So we need to get involved in the family, find out who is financially competent, who is the best in terms of health and health directives. And really we start to build estate planning, not just for one person as a lawyer would do, or mum and dad when we're doing mutual wills. What we're going to do is estate planning for the whole of the family. And when we have a look at it, and this is one of the big reasons that I've always argued, and I did this last night. Tony and I had a client who built a Moat with their accountant. We went through the process. We're about to show you very shortly. And one of the issues there is that we said, look, bring your children into your fund. They're going to be the next leading members. Bring them into the fund. Even if they've got small account balances, it doesn't make any difference. From that perspective, if something happens to them, then we suggest that perhaps the earnings of the fund be used to provide TPD or total and permanent disability. That now means that there's a whole raft. The fund is bigger than it looks in case someone dies. So we need to start to do estate planning. And that's particularly prime if those children have grandchildren. You don't have grandchildren, have children, which are the grandchildren of the parents. Bring them into the family fund so that any pension that's payable on the death of the child, and if they're bloodline children, can be looked after in terms of that estate through the SMSF directly, not through a will or testamentary trust. Never. We don't want to get over there. The last resort is our estate is actually burgeoned through the will and testamentary trust, because we know it's going to be challenged. In fact, do you know, here's an interesting fact, do you know that New South Wales has the most legal students that graduate each year, percentage of or per head of population than any other place in the whole world? I would have thought it'd been California, but it's actually New South Wales. Those lawyers need to do something. It's usually personal injury claims or estate planning claims. Anyway, well, let's have a look at the estate planning. I'm not disparaging all lawyers. They are. There's some awesome ones around. I know Tony Annamulis, certainly on the warmth side, he's right up there, and on the knowledge competence side, he's right up there. So he's one of the tippy top lawyers, but they're not all the same. And that's quite often when you go and get your estate planning done, it's a pot shot. You don't know what you get. In fact, I'm sure if I went to my local solicitor here in Sunshine Coast, I'd end up with even the best, the most famous solicitor on Sunshine Coast. I'm sure that they would direct all my SMSF monies into my estate. And the last thing you want is that to happen. I mean, even if you think about it, the process, if you've gone through it with a client, you'll get your estate, it's got to go through probate. It takes weeks to settle. If you have an SMSF will, which is essentially a set of binding directions as to what happens on the death of yourself or it's your client, that can be settled immediately, absolutely immediately. As soon as you get the death certificate, bang, you already know if there's a reversionary pension, it immediately travels to the next person. The same thing with an SMSF will. If you've got a specific bequest that a farm is going to an adult child, straight away it can go down. And that's the key difference between a will and testamentary trust. That's the Moat style. I mean, really, if it's going down there, if we have a look at it and we've got SMSF benefits there, and we've got lawyers trying to attack from all angles here with their arrows and their horses, if the superannuation fund estate has already been settled, been paid out within 12 hours or 2 or 3 days, then obviously that is going to make a huge difference. So let's go through this estate planning case study. John Smith is a 60-year-old doctor with his own practice and is also a locum at 2 local hospitals. John wants to retire in the next 3 years to go cruising the world with his wife, Sally, a 58-year-old charity worker and homemaker who hates finance, money, and all that stuff. John and Sally have 3 investment properties worth a total $2.2 million in a discretionary trust where he is the sole appointor and sole director of the corporate trustee, a SMSF with $1.4 million in his lump sum account and $1 million in Sally's account, with John and Sally as trustees, and he lives in a $2 million mansion owned jointly with no tax debt. In fact, he has only $300,000 debt on all his properties, is paying a bucket load of tax. Well, this is about estate planning, but obviously there's a whole lot of strategies that we can build out of here in terms of tax planning. John and Sally have 3 children. This is the key when you're estate planning, finding out on a scale of 1 to 10 how sensible these kids are financially. Now, we've got Max, age 35, is a successful stockbroker, and according to John, a chip off the old block. So he's probably up around about a 7 or 8 or even a 9. Sarah, who's a 32-year-old doctor working in country New South Wales, we'd find out what she is on a scale of 10. And Jody, who is currently in rehab for substance abuse with her boyfriend of 5 years. Are the bells starting to ring now? Can you start to see there the potential of problems? If monies go to Jody, then instantly the boyfriend is going to have a challenge under family law. If something happens to Jody, definitely a challenge in terms of Family Provisions Act if she passes away. But more importantly, if John and Sally pass away, guess what? Jody's boyfriend could get in Jody's ear, go and see a lawyer and start to attack the estate. Now, John did a will with his family solicitor in 2010, which is a very old will, giving all of his estate to Sally and a BDBN directing the trustee of the fund to transfer all of his superannuation to his estate. That starts to ring alarm bells. If Sally was not alive, then his 3 children were to divide the estate equally. The executor of the estate was his old golfing buddy, Fred, who was recently diagnosed with early onset dementia. Sally holds John's enduring power of attorney while he holds Sally's EPOA. So how does that sound to you? I mean, how would you work with that one? Now, it could be that this might be 1.1 million. It doesn't matter. It's the quantum. So this is my solution. I'm going to unpack this and then I'm going to show you what to do. Importantly, from this perspective is you're going to need to watch this at least once or twice again, perhaps over the Christmas holidays. In fact, the prime time to think about family and get your wills and testamentary trust into gear are over your family. In fact, my Christmas gift to you, apart from this session, is going to be an ability. I'm going to give you a log on and a credit for those of you who want to reply to our team. I'm going to give you a credit for using the Moat so you can build the Moat for your own family circumstance. And that is valued at $450. And we saw it at work last night, Tony and I. Again, we saw an accountant build one with his client. And it was amazing. We then sat down, and this is the process, particularly if we're doing wills and testamentary trusts, we want to have legal sign-off. We don't want someone to come back and say, well, hold on, you're an accountant, you're giving legal advice. You can prepare all the Moat documentation. And then what transpired last night, we all sat down with Tony, who's a practicing solicitor in all of Australia, across all of the jurisdictions in Australia. We sat down and we went through all of the documents as part of the Moat. Tony asked a whole lot of far-reaching questions about the succession. Would they like to do this, like to do that? We reviewed the documentation, and at the end of the hour, Tony signed off on the EPOA, the SMSF Will, in fact, the trust deed upgrades, and also the will and testamentary trust that the accountant had prepared with the client. It now becomes an Abbott-Morley document. Now, of course, the accountant can then charge for that whole facilitation process, but at the end of the day, the cost was $495 to complete that 1 hour Zoom, and the client has now got a recording of that Zoom for posterity, and Tony also has that in his vault at work. So let's go through. So first off, the EPOA. So I would establish a new EPOA for John to replace the current EPOA with his attorney being his eldest son, Max, and in the event that Max is not alive or incapacitated, Sally and Sarah, with Sally having the binding vote in the event of a tied vote. Now, what we can do is you can actually split. Sally would probably be perfect for an EPOA from a health directive point of view. But when it comes around to finances, and remember, whoever has our EPOA can automatically, if you're using a LightYear Docs leading member deed, can automatically step in and take control of that fund. So if John says, I don't want to act as director anymore, and Sally says, I don't want to act as a director anymore of the corporate trustee, of course, we'd want to change our trust deed and upgrade it. Remember, we don't want to have the individuals. Then in that instance, if Max has the EPOA for John and has the EPOA for Sally, then in effect, Max can run that fund. And if it's Max, Sally, and John in that fund, then, and let's bring Sarah in as well, then we could have Max as the leading member and a director, and also Sarah as a director as well, if we want to have that. So when we have a look, the EPOA would be for health, finances, and also known specifically as for superannuation replacement. In an EPOA, you must have that's also for superannuation purposes and that it has effect on execution. I see time and time again, Tony and I just shake our heads when we see EPOAs that do not take effect until someone becomes incapacitated, because they're absolutely useless when it comes around to superannuation. You need to have superannuation, and you can have a superannuation quite separately. If you'd like to have a look, I did a big session, a webinar on EPOAs, which is up on our support centre on LightYear Docs. At the same time, Sally's EPOA would have John as the attorney, with Max as the successor attorney in the event that John dies or is incapacitated. Both EPOs would commence once the EPO is executed, not incapacity as lawyers normally draft. And so what I'll do is I'll show you all this, because it's all part of the Moat. The discretionary trust. So John is the only appointor, which is an absolute disaster. So what we want to do is add Max as the successor appointor, and then after Max, work out who will come in after that person to the discretionary trust in the event that something happens to John. If Max is not alive or is incapacitated, then Sally and Sarah, so the daughter and the wife, become the second successor appointors. Put Max in as a director of the corporate trustee of the discretionary trust, and also retire Sally. That's a much better way. Note, the discretionary trust does not form part of John's estate. With our newly built succession planning for the trust, we created a moat around this structure. We're not going to go into this today, but we can go into the LightYear Docs site for the price of $99, put in succession appointors. Now notice the succession that we're putting in for the discretionary trust looks exactly the same as the succession that we've put in for the EPOA. What we're doing is we're giving Max control of the whole family's position there, and that's the way it should be. Leading member SMSF. So we want to set up a leading member SMSF. Now, what is a leading member SMSF? Essentially, it's a new vehicle, it's a new entity that I've created out of a whole lot of consternation from clients around what happens to their superannuation and estate in the event of the death. They want security, they want safety, and they want certainty. So the leading member is the titular head. So in this instance, John is the leading member of the fund. That means he can hire and fire the trustee. So we've got a corporate trustee, but if John doesn't want that corporate trustee anymore, he has power under the governing rules of the leading member SMSF deed. He can fire that trustee. And that's absolutely important if we have divorce or separation, a whole range of other issues. Now, also, he can appoint and remove members. So, for example, we've got Max there, and we've also got the daughter, Sarah. Sarah might be inside the fund. If she gets divorced, then effectively we can remove her, put her over into an industry fund until such time as the divorce or the spouse is settled, and then we can bring her back in if we want to do so. And of course, we could leave Jodie can come into the fund, even though she's had a rehab problem. But if there's any issues, we can flick her out of the fund straight away. Of course, we'd be waiting for the 6-member rule on that one. So we've got John as a director. We get rid of, because he's got Sally's EPOA, Sally is out. She doesn't need to be a director anymore. It's a waste of time. So he's actually going to act on behalf of Sally. And we'd be bringing Max in as a leading member and director, change the SMSF trustee to a company, so it'd be a leading member corporate trustee, upgrade the SMSF to a leading member SMSF with John as a leading member, followed by Max on John's death, incapacity, retirement, followed by then Sally and Sarah. See what we've done? It's the same succession as the EPOA. It's the same succession as the appointors of the discretionary trust. As I said, leading members have the power to appoint and remove members, hire and fire trustees, and hold veto power on all trustees' decisions, except when you're doing a member-directed investment strategy. There's only that member who can actually have power around their investment decisions. But otherwise, the leading member can have power over, or veto power over all trustee decisions. Reversionary pension. Retire John immediately. He's over 60. Give up one of his locum positions. He's over 60. By giving up one, he can still work full-time as a doctor, as a locum at the other hospital, but effectively he's deemed to be retired under SIS regulation 6.017. Now, John would set up a reversionary pension that's got estate planning built in. Again, a reversionary pension does not form part of his legal estate. It cannot be challenged on his death. If you have a look at a whole range of cases, whether it's Donovan, Katz and Grossman, there's a whole range of them where people outside have tried to attack. Beneficiaries outside thought this is like a family provisions claim, and we're going to attack the SMSF. Effectively, everyone has fallen foul. So John's to set up the reversionary pension, goes to Sally on his death, and then on her death, or if she's not alive when John dies, it's payable to the 3 children equally, but as a lump sum commutation into a SMSF Death Benefits Trust, where John is the appointor, followed by Sarah. So what the hell is going on there? Well, what we would do is that when Sally dies, we're actually building in this reversion to actually go to the adult children. It would go into the adult children. We'd create a leading member discretionary trust, and we'd call it the Smith or the John Smith leading member, or the John Smith Family Death Benefits Trust. Whatever's left over goes in there. John would be the appointor. We then have Sarah as the second appointor. He's the leading member appointor, and then we'd have the beneficiaries being any of the 3 children, and any of those children that are lineage or bloodline of John or Sally, if you can understand what's going on then. And again, we can start to build these. Now, it doesn't have the tax advantages of a testamentary trust, so that any legal benefits going out or distributions going out to grandchildren who are under 18 are taxed at the penalty tax rates. But we're assuming there it's actually going to be paid out to adult beneficiaries, included part of their marginal tax rates. But what we've done is we've gone safety first rather than the off chance of succession. So again, anyone, if you'd like to ask a question later on to Tony Tanamoulis at abbottmorley.com.au. We've got here John Hamilton. Good question. Do each director of the corporate trustee have to be a trustee or director? Absolutely not, John. In fact, what I'm saying here, and if you have a look at my EPO session, then what we've got there is a lot of your clients, if they've got an EPOA, so if we work on that, so in this instance, we've got the homemaker and the charity worker being Sally, who doesn't really want to do financial stuff. Why should she be a director of the corporate trustee, particularly when the commission is getting very aggressive in sending out notices around investment strategies? He's about to send out 13,300 letters to SMSFs he has discovered who don't have their own separate bank account. The last thing Sally wants is to receive a letter like that. That would freak her out. So I'd say for a lot of your clients, look at a position. If they've got an EPOA, just resign as a director of the corporate trustee. If you don't want to be there, as long as you leave that leading member, and that's the beneficial and all the benefits around it. Super contributions. John and Sally would keep on contributing to super, with John and Sally taking pension payments. He's only got 1.2 million super, so keep on contributing in there. It can be salary sacrifice. Now remember, John and also Sally, not quite yet, so she hasn't reached her preservation age. She's going to get very close. Effectively there, that money would come out tax-free. So he can continue to salary sacrifice into super. We just have to watch out for his general transfer balance. So he obviously, once he hits the 1.6 million, he can't put anything above his SGC or his superannuation. Now we want to do an SMSF will to be created for John for his building accumulation account with super benefits to go to children. Now what will happen there, that goes to an SMSF Death Benefits Trust, but the reversionary pension that we're building straight away for John, obviously that's going to be excluded from the estate and also the SMSF will. Now, the will with a built-in testamentary trust. Now, create a new will in TT, but this is where things get funny. If we have a look at it, all of John's assets are in his discretionary trust, which sits outside the estate. All of his superannuation is going to be distributed straight from his superannuation pursuant to the Commonwealth law under the Superannuation Industry Supervision Act. So that is actually covered by the Commonwealth Crimes Act. If we've got a good SMSF will, that is impenetrable. His house, his $2.2 million mansion outside, effectively is held jointly with his spouse. So if we use that position one there, if John dies, that house automatically goes to his spouse. If we go back to the Andre Taylor case, it was surprising he didn't have it jointly held with his de facto. It would have blown up that whole estate anyway. So when we have a look at that, really, when John dies, there's not that many assets at that point in time. So what we've done is we've done a brilliant job of asset protection. So in effect, there's not that much to do with will and testamentary trust. We would still do that because we don't know what's going to come down the track. But we want to keep this moat, a moat around the discretionary trust, a moat around the SMSF, and then what's left over, try as best as possible to create a moat around your will and testamentary trust. But bear in mind, remember the Family Provisions Act. I've got a good question from Ken here. How do you set up a pension if a member dies before pension age so as to leave their member's balance in super and paid as a pension? Well, we do that. That's a really good question. In fact, I'll look at that, Ken. That's a really good question. We can do that through the SMSF Will. So a reversionary pension could pop out of the SMSF Will. Let's say that we haven't set up a reversionary pension for John yet. He died yesterday. So what we can do is we can go in, if he's got his SMSF Will, we can then pay a reversionary pension to Sally and then to be split to the 3 children equally. In fact, we haven't got kids at the moment, but once they have kids, if you can show that they're financially dependent, we can be in a position of paying it out to grandchildren, and that is not caught by the maximum 25 years of age rule. We can pay that as account-based pension. And we've got an anonymous attendant. If an EPO only comes into effect upon permanent capacity, how does this work for Sally? Really good question. We don't do a POA. What we do is, if you go back and you can record this on our enduring power of attorney, I'm going to show you now because we're about to jump into the moat. What we have there is, in effect, we want our EPOA to start immediately, not when there's incapacity. If you've got a client or you've got yourself and you've got an incapacity issue, that's only when that starts, then you've got a problem there. So let's go through just another one, the LightYear Docs Strategy and Support Center, SMSF Will Client Fact Find. You can also see in the Support Center, which is on the front page, all our webinars and trading videos are here. This will be produced up here. You've got investment strategies, comprehensive estate planning. This will pop up here shortly, so you'll be looking for that later. So what I've got here is I've got a comprehensive estate planning. It's the Moat. So what we're going to do is I'm going to put, because we're going to get sign off, for those of you who are on our licensing or on our unlimited subscription, which is $7.95 a month, or if you don't want CPD, etc., and technical support, it's $5.95 a month. But for those of you on licensing, then you can give us your logo and you can actually produce documents with that logo. I would suggest for the Moat that you'd want to put Abbott-Family logo on it so that it shows that it's actually got legal prowess. Now, as I go down, hopefully you can see just a couple of little things that we want to put in. Save answers. So you want to save answers on the way through, which is really important if you want to go back and check. You can preview files. See that little button there at any point in time. These are quite expensive little add-ons that we've got for our site. What this does is enables us to preview the whole estate planning package, the Moat, through the EPOA, etc. And I'll have a look at that. Another one that you want to do before you might finish, or you can actually use for the client, is you can actually do this summary of all of the questions that we're going to ask. So you've got all of those little tools there for you, but let's go back to the interview. So what I've got to do now is I've chosen, with this Moat, I'm going to do an EPOA in New South Wales. Now I could do it in any state, but I've chosen New South Wales. Now I can upgrade the constitution if I've got an existing corporate trustee to a standard, or you can upgrade it to a leading member constitution and a leading member deed. Now, one of the things about the leading member constitution is the only shareholder. So if currently you've got a company that's got mum and dad a shareholder, and you want dad to be the leading member or John to be the leading member, get rid of Sally's shares by cancelling those shares. Dad's a leading member. On Dad's death, automatically under the Constitution, his shares are cancelled and then they're transferred, not transferred, new shares are issued to the next leading member, which in this instance would be Max. We're going to do an SMSF will and we're going to do a last will and testament. So we're actually going to do all of those documents. This is the Moat. As I said, the discretionary trust you would treat quite separately. You just put in successive appointors around that. So common parties, this is where really makes a big difference. So we put in place all our common parties. You can simply add another party at any point in time. So I've got John there. The next one I've got is Sally. The next one I've got is Matthew. The next one I've got is Ben and William. These are the ones from our earlier case study. Sorry, I haven't updated these. In fact, what I'll do, I will change this to Max. It just shows you how easy it is. You can go back and change. So Max. Next one, I'll call that Sarah. And the next one was Jody. I then go in and Marie, who knows, we'll call it Cecilia Smith, who is John's sister. Just shows you. Then I've got the company. So I'm assuming there I've got the corporate trustee of the SMSF. I've put in that company name. Now I'm going to upgrade that anyway. I'm also going to put in here, which is important, Beth Smith, again, another sister that I've put in. I can delete that. And also put in your details because that's going to come up. Sam Accountant, or you can put in Tony Animoulis. You'll put in your details because you're going to look after the will and also the SMSF will. So we've got all those common parties. So the first step is we're going to do an enduring power of attorney. Now I've chosen the New South Wales one and I've put in there John Smith, the principal. If I wanted to make it Sally Smith, then I just simply change and that changes all the details, but we're going to leave it as John there. Then who's the attorney? Well, remember, we've got Sally there is the first attorney and I've added another one. So I've added Sally and Max to the equation in this instance. So that's a bit different from the case study. I've actually put those in. We've had a bit of grief from Sally because she's not the attorney. So we've actually made Sally and Max both as the attorney. Substitute attorney, we've actually gone Cecilia Smith, but let's change that. We might go to Sarah Smith. We'll put her in. So that's the substitute attorney. The power of attorney, act on behalf, I could do, if I just want to do super, I could do act on behalf of the superannuation fund, including as a replacement trustee. It needs to be specifically included in there. But here, I'm going to actually make it for the whole deal, personal, financial, and super. You can see there, I've got the choice. Normally, most people or most lawyers would choose a medical practitioner considers a principal is unable to manage his or her affairs. But here I'm going to do upon signing the document because that enables me, if this was for Sally, it enables John to act as her replacement director. Does the principal want to revoke? Yes. Is Tony Animoulis of TGA your lawyer who will certify the enduring power of attorney? Well, if you're going to have that meeting with Tony, that will actually do the whole lot. You go yes, otherwise you go no, and you can get your local attorney or local solicitor to effectively do that. But you can also get just a justice of peace to actually do sign off, except for New South Wales, it needs to be a solicitor. So the day to confer living expenses, well, we just leave that at the moment. State additional powers, or you can put conditions. That's up to you. Again, this is replace. So we've done the APOA. Now we're actually going to do the SMSF. So we know the trustee. We've already put that trustee in. What I do is I can just choose the company name and the party there. I'm upgrading it to the leading member, special purpose corporate trustee, which I've done there. So I've got the special purpose company that's been upgraded. We've got John and Sally there. This is before Max actually becomes a member. So I could, if I wanted to, go another member if I wanted to. I then do an upgrade of the constitution. Now, as I said before, John and Sally were both shareholders. I've cancelled Sally's shares and John is the only shareholder. So he's the one, it's only the shareholders who can upgrade the constitution. So it's like a complete upgrade of the constitution to the leading member. Now, what we do now is who's going to be the leading member? We've got John being the first leading member. The second one, we've got Max being the leading member. The third leading member, we've got Sally. And if we wanted to, we could add an additional one there. But we've left it just as Sally as the third leading member. I could have put in there, I've got the second leading member. With the third leading member, I could have also put in, for example, Sarah as well, and they could have jointly held leading membership as well. As you said, this was done from my roadshow recently. So I've upgraded the deed. I go in and I find out where the upgrade's going to be. When was the document first created, or when was the deed established? It hasn't been varied. So I put in that detail. I put in the clause which allows me to vary. If I have to have a principal or founder or another leading member, I could put that in and then they would pop up who's the other person, who's the signer, but I don't in that instance. And then that provides me with the deed of variation. I now go into the SMSF will, and again, I've chosen this is for John Smith. I've put the nominations. Does the member want to revoke earlier nominations? Yes. Does the member want reversionary pensions to take precedence? Yes. Otherwise, what's the purpose of doing a reversionary pension in the first place? Does the member want to appoint the executor as a replacement trustee? Absolutely, because the executor in this instance, when we get the will, is going to be Max. Does the member want death benefit payments, including pensions and lump sums? Yes. Do they want a professional look after the estate? Yes. And in case the fund is non-compliant, do they want a catch-all clause? So it goes out to his estate or just bloodline. So here I've got specific bequests to Matthew. So in fact, it's now Max. And also, just shows you how easily it can be changed, to Sarah. They're each to get $200,000 cash from the members' accumulation account. Now, if there's nothing, if that's not in the members' accumulation account, then it's proportionally withdrawn. But we have to look after that bequest before we look at any other one. So we've got Sally Smith as the main beneficiary. She's the spouse. She's to get an income stream. So again, Ken, if we've got an account base, we can actually set that up as an income stream. Now, do you want to put terms and conditions? I've got a reversion income stream payable to Sally with any remaining capital on death to be split between my bloodline children as they see fit according to superannuation laws at that time, or by a SMSF Death Benefits Trust. And that now pops up into the document, as you'll see. The residual beneficiaries, I've only got to be another 5 more minutes, so sorry it's gone a bit longer, but as you can see, this is an important case study. So the residual beneficiaries are going to be Max and also going to be Sarah. Now, of course, if we wanted to, we could also bring in Sarah and Jody Smith. Now, of course, they're obviously concerned about Jody being in that relationship. So we can leave her out. She's got no way of challenge. Nominated professional, we've got their Sam accountant, 3% of a superannuation balance we've put in there is actually his fees. Wouldn't that be nice? Or normal partner accounting fees. We then go down, we have the meeting, the binding death benefit, last will and testament. Is there a life interest? No, because obviously it's held, it's jointly held by Sally there. Got the testator, I've chosen John. The executor, I've got Max, who's the son. And then I've got Sally as well. So they go through. They're also remember all the leading membership, the EPOAs and all that. Successor executor, I have chosen Cecilia. Let me go in and we'll actually choose Sarah in this instance. Is the successor executor. Binding vote. So in the event, because we've got Max and Sally, who's going to actually have the binding vote? Let's give that to Max. Then we've got the estate beneficiary. I've got the spouse. So I put in the spouse. She's the main beneficiary. I've also got Max as a second beneficiary. I've got Cecilia. So let's actually make it child. So that is going to be Sarah. And then I can add another if I want. So another child. I put in there Jody. And effectively, does she have her own children? And we've got no. So is there any specific bequests? Yes, I've got the estate beneficiary, specific bequest. There I've got, let's say, we haven't got any property, so we can just put in there. Actually, what I'll do is I'll say no, because we've virtually done the whole estate. We'll say there's no specific bequests. So we've done it all through the super fund, the discretionary trust. So I've gone through that process with the client, and effectively that finishes it. So then I finish it, done all those parties, and up pops the documents. And it's not just one. Oops, sorry. The interview session is expired. So let me just go up here. You'll find it's probably in my in progress docs. And I'll go down to the Abbott-Family, which is where I had it. And then I've got the Abbott-Family, which was the, so the Abbott-Family I just did then. Let me just go back. Okay, so it doesn't look as though it is there. Let me go back into the launch. And what happened is, because I've left it open all morning, because this is legal, you can't leave things open for a long time. I should have saved on the way through. So I've got the comprehensive estate plan, and that should be for the Smith Moat. So I just click on that and I open that one. Just got to be very careful. Save answers. So I should be able to tell principal, attorney, Sally, Max here. So it's kept all the answers anyway. But what I'll do now is I'll finish it and the document should pop up. So just remember, you can relaunch at any point in time. Just go back into your vault, look for the document. That's why you name it as you do. And then up will pop all the documents. I'll just show you really quickly, and then what we'll do is I'll close up the session with the last slide. So I download, and I'm downloading all the documents, and it all comes up in a PDF. Now, if you've got to make changes, if you've got to make changes, then what you'll need to do from that perspective, just go back, give it to the client in a draft form, and go back and effectively you can go back into the relaunch and change any details. In fact, you can keep this going for ad infinitum. So we've got John Smith, you've got your EPOA. You've then got, I think if we go down here, you'll see there it's for superannuation and all matters lawfully. And they can give gifts, they can give the whole start. So if we have a look at it, it starts immediately. You sign it, and then we go down. We can go down a little bit further. So that's it. Then we've got the constitution upgrade to special purpose, corporate trustee. And then we'll go down further. That's signed by the only member, which is John Smith. And what I mean by that, it's the only shareholder. That's your leading member. As I said, it's veto power. Shares are transferred automatically. So we go past the constitution. We're then going into, you can see here's an upgrade of the deed to the leading member deed. So we've got the variation there. And that's obviously the Smith Superannuation Fund, the trustee. We've got who the leading member is being appointed, so on, and who's the second leading member, third leading member, etc. We then go down to the actual deed itself. Then we should go down to the next one is going to be our, if I just scroll down, sorry, just having problems with here. If I then go down, sorry, it's such a big file, as you can imagine. You've just got to be careful. If I go down, you can see there, this is all the relevant clauses for the deed itself. The next one we're going to get to is going to be the SMSF Will. So we've got a PDS there for the SMSF Will, and we go through that process there to the will itself, which is here, application by John Smith, As you can see, there's revoking earlier nomination, reversion pensions to take precedence, appointment of replacement trustee and member, death benefit payments, specific bequests that go into death benefits trust, spouse income stream option. So it goes to reversion income stream payable to Sally with any remaining capital on death, residual beneficiaries, Jody, which can go to death benefits trust. Then we sign off, the trustees have a meeting, they resolve to accept that as an SMSF will, becomes binding. And then you go to your last will and testament. So again, revocation of the earlier ones made by John Smith, appointment of trustees, we've got Max and spouse Sally, Max to have the binding votes, ongoing trustees if you wanted to build a testamentary trust. So this has got inbuilt testamentary trusts, which are at the direction of the executor, which is obviously going to be Max and Sally in this instance, with Max having the overriding vote, and we can make those non-vesting testamentary trusts as well. Initial administration, beneficiaries, so on and so forth. So basically, if we have a look at it, that's all of those documents that are sitting there, and that all can be done in one run. Now, at any point in time, I can always go back into this process. I can relaunch, and I might just want to I'll go back to my vault. I go back to the Abbott-Family, and I just want to show you. So I'm going down to the Moat. So again, we've had a look at the Moat here, Smith Moat. Now I might relaunch it, and I might actually only need to change the EPOA. So things have happened. We're actually going to change the EPOA. So I just go to the documents. I'll get rid of this, get rid of that. And effectively, now I've just got an EPOA, which I can now change. So what I would suggest is the Moat is perfect as an all-encompassing vehicle for you to do for each client. I would do a Moat for Max. I would do a Moat for Sarah. I would do a Moat for Sally. And again, if you're doing Sally and also Sarah and Max, you're not going to have to do all the upgrades because they're already done. You just go through your will, your testamentary trust, and also your EPOA. So if Max is present in or lives in Queensland, you just go through and do that, and that would change that. So let's just finish up with the final slide. And when we have a look at, first off, the 4 takeaways from this session. You can do this. As I said, I gave you the 5 reasons why I believe that accountants and financial planners can take this process there. It's not legal work. If you get us involved, get Tony Anamoulis from the position of doing that Zoom with a client, then the legal liability transfers to Tony. It's $495. We will pass that cost on to you, and then you can charge $3,000, $4,000. If you went and did that Moat, an EPOA, constitution upgrade, a trustee upgrade, an SMSF will, and also a will and testamentary trust. If I went and asked that with my local, even the most famous estate planning lawyer in Sydney or Melbourne, then you would find in that instance that that would probably cost you at least $10,000 to $12,000, mainly because it's going to take, maybe 20, because it's going to take them a lot of research what an SMSF will is. But essentially, it's up to you. You can make sure that you can charge. You know your client structures and their family. We've automated the work for you. As you can see through that automation, we just get the clients. The main one is focus in on that succession. Everything else fits in really easily. Look at the learning. If you want to have a look at my whole, you can jump online, and I think if you go to the I Love SMSF, you can actually get my whole 1 day that I spend on those 20 strategies. You can get that for $99. Work out your pricing. As I said, it's up to you. But again, this is just a super opportunity. The main one that I would look at is, let's finish with my mate, Richard Branson. If somebody offers you an amazing opportunity, if you're not sure you can do it, say yes, then learn how to do it later. Anyway, it's Grant Abbott. Hopefully you've got, I'll just check if there's any other questions that we've got. We've got, if EPOA is effective immediately, would it be risky? No, not at all. It just depends. You can actually, remember Kenneth, when you had a look in the EPOA, if I go back and look here, sorry, Kenneth, that's really good. While you're here, it's a good question. if I go back and have a look at my EPOA, remember I did this, I'll go to New South Wales and I'm going to do my EPOA. So I've got my enduring power of attorney, I've got the principal, and I've got the attorney, and then I've got substitute and power of attorney. As you can see there, I've done upon signing of the document, state additional powers or conditions. Only my superannuation powers are to apply immediately. Any financial powers apply when I am incapacitated. So that's the way, a really good question, Ken. So that's why I'd cover that. And you can always ask Tony for the relevant clauses there that you would like to put in. But that's an excellent question. I've also got here. So that's perfect. I've got Ken, incapacity, not necessarily permanent. So is it not a major concern that too much power is placed on one person? That's a really good question, Coy. This is an issue you need to discuss with your clients. But for example, if Max is not the right one, then we can actually make it Max and, for example, Sally, as I've done in here, or Max and Sarah, with Max having the binding vote. Each client particularly will want to have their own specific. We dealt with a Vietnamese family recently, and they wanted the eldest son to really take control over everything. And also we had to put in designated beneficiaries into the discretionary trust. You don't know what you don't know, and that's why the accountants and the planners are a great position, because you can deal directly with your clients to find out and try it on. Have a look at my podcast on I Love SMSF, or on Spotify, go I Love SMSF, and there's a great session we did there with John Grokey. Have a listen to that, and he goes through the process he talks about with leading member and pressure. He finds that 80% of all his clients want to make sure there's good, strong succession planning. So again, Kenneth Ang, that's a really good question. I sort of that. Any ability to bring trust into comprehensive estate planning? Peter, I have done that. I've actually got, if you can just indulge me. So that is what I call the normal moat. If I just go in here and I'll show you, I think I'm going to do some training next year around this. What I want to do is I want to get involved in a 2-day training if you're interested. I'd love to, so I'll call the full moat. Oh, sorry, I haven't got that. So I'd love to actually be able to train you guys if that's possible. If anyone's interested, we'll get for 2 days in, whether it's in Sydney or up here in the Twin Waters, up at the Novotel there. We'll come in and we'll go through the whole moat really carefully. So that's what I call a mini moat or normal moat. So the one, Ken, that I'd be using, that would be training on, is the estate planning package. So I go through exactly the same here. It's not launched yet, but the documents are enduring power of attorney, but notice deed of appointment of successor appointors and variation of the deed to add designated beneficiaries. And it also includes family allowance agreements to show dependency relationships for clients. So when the money goes out to the adult children, particularly if you have a look, that you can show that they're financially dependent, it goes out tax-free, and also includes pensions and reversionary pensions there. So that is the full enchilada moat. But I suggest I'm going to give you the opportunity of building just the ordinary moat for yourselves, and then go down the track of doing that. Kenneth, if you want to do 2 attorneys to act jointly, absolutely. If you want 10 attorneys to act jointly, you can do that. The thing is, it's up to the client, but I'm going to give you the opportunity to build your own. And then essentially what we can do from there is, once you build yourself, you can actually start to walk your talk from that. Anyway, it's Grant Abbott signing off. There's a lot there to unpack, something to listen to over the holidays. You will be getting as I said, a login to do your own Moat under our comprehensive estate planning package. And if you've got any questions, contact Tony, which is tanamoulis@abbottmorley.com.au, or myself, Grant at ilovesmsf.com. And we'll leave this and we'll send you the recording very shortly with that login, with those credits if you want to go through, and we'll give you a process. But the workflow for a comprehensive estate plan, which I call a Moat, or the full Moat, is there for you. Use it. And I can tell you from what we saw from the ones we've done recently for clients of Abbott-Morley, it takes a huge weight off their shoulders, knowing that their whole estate is safe, certain, and secure. It's Grant Abbott, signing off.